This is Jonathan Yates with HBCU Game Day Network. With us is Richard Giller, a partner in the Los Angeles office of Pillsbury, Winthrop, Shaw Pittman. Mr. Giller, thank you for joining us this morning.
Thanks for having me, Jonathan.
Well, so since you're out in Los Angeles and I used to live in Malibu, I feel obligated to ask you, how's traffic on the 405 this morning?
Well, the fires, it looks like we're getting some of them under control, and so traffic is a little better than it has been lately.
That's wonderful to hear. So speaking of California, the California legislature really moved and upset all of college sports, and the NCAA had to reverse Pittman. Can you tell us what happened?
Well, sure. And I guess it was September 30th, Governor Newsom signed a bill that was in the California Senate called the Fair Pay to Play Act, which basically allows student athletes in the 24 public California university system and Cal State University system schools to profit from their name, image, and likeness through endorsements and signing endorsement deals, which kind of runs contrary to the NCAA's amateurism requirements and has caused somewhat of a firestorm.
Now, when the NCAA first came out, they said they were going to go Kaiser Sose on the California schools and any other states that passed similar legislation, but then they reversed position in October, 1 month later, and dialed it back from DEFCON 1 to DEFCON 5. Why do you think the NCAA did that?
I think there's a couple reasons. It's interesting. It's almost exactly 30 days after the bill was signed by the governor that the NCAA Board of Governors made their announcement. I think that was October 29th. And it's funny that the California bill doesn't actually take effect until January of 2023, but the fervor over it was getting to a fever pitch. And I think the NCAA Board of Governors really just wanted to sort of stop other states in their tracks from passing similar legislation, because New York and Florida and Washington and South Carolina are all considering similar bills. One of the aspects of the California bill is also to stop the NCAA or schools from prohibiting athletes from using their name and likeness or getting paid for using their name and likeness. And so it was causing a potential rift. And I think the NCAA just bought some time. I think they wanted to, tone down the fervor over it all, and they're really asking the divisions, the Power Five conferences, to look into it and then get back to them in January of 2021. So it sort of makes it appear as if they're doing something and kind of going the same way as the California law, but instead I think it really just buys them 14 more months of studying the problem. When the California Fair Pay to Play Act was signed, the NCAA issued an announcement calling it unconstitutional. It's their position that states don't have any authority over the NCAA, and the NCAA is only bound by federal law. So I think the real issue is going to be what happens in Congress. Does it get to Congress? Does the House of Representatives pass a bill similar to California's? Because if various states do it, I'm not sure the NCAA is going to do anything other than keep saying unconstitutional.
Now, we had Congressman Mark Walker on our show last week. He introduced legislation in March of this year to basically allow for the same thing. He introduced it with Representative Cedric Richmond from Louisiana. Do you think California was moved by that legislation?
Possibly. I mean, Norm Chad had a great line in one of his articles discussing the California Fair Pay to Play Act. It's a tongue twister for me, so sorry I stumble over it.
It's early out there.
He said that California is often a punchline and often a pace setter, and in this instance he called us a pace setter. So we'll see, other states passing legislation, and then we'll see what happens on the federal level.
So you've been working in these issues for a long time as an attorney. What do you see as the major issues now before college sports?
Well, stepping back to the Fair Pay to Play Act, a couple of people have come up with an idea that maybe what you can do is have college athletes profit off of their name, likeness, and image by having the money paid into sort of a third-party clearinghouse or a third-party trust fund. And maybe in that way you can salvage the amateurism as well as allowing the students to earn money off of it, and then the payments received will earn money in a trust and get paid out after they graduate. That's one option. Or maybe there's a way to have a trust pay it out in increments. And I mean, I think, so getting to your question, the real issue in college sports is NCAA had $1 billion in revenues in 2018 and a profit of $27 million. The Pac-12 conference issued a statement about the Fair Pay to Play Act, kind of calling it the death of college athletics. And yet the Pac-12 commissioner earns $5 million a year. And why do these people make this much money? Because the student athletes are making money for the schools. And so, I'm a big proponent that student athletes should be able to earn something other than their college scholarships and room and board for the millions and millions of dollars they earn for their member institutions.
Now, Senator Richard Burr from North Carolina, he came out last week after the NCAA reversed his position and said, that's great. If the college athletes are going to be making money from playing from the schools now, they're going to start paying taxes for it. That brings it into your world as an insurance recovery specialist. What are going to be the tax implications for someone like a Zion Williamson who receives a $50,000 insurance policy paid for by the NCAA through Duke if they're starting to be taxed?
So that's a very interesting question, and I've sort of been on the forefront of where this should go. The IRS, first and foremost, let's start with my preface. I'm not a tax lawyer.
Sure.
I don't profess to be a tax lawyer, nor do I ever aspire to be a tax lawyer. So none of this is legal tax advice. But the IRS has issued a publication earlier that said, if I, as an individual, purchase disability insurance and I use post-tax dollars to do so, the benefits paid out under that policy are tax-free. However, if my employer purchases the disability policy for me using pre-tax dollars, then the benefits from the disability payouts would be taxable. So the IRS wants to tax something. They want to tax either the money you receive before you make the premium payment, or they want to tax the benefits. So what happens in the college athletic space where a college or university pays the premiums for student athletes? No one knows exactly. They're not employees, so it's not like the IRS publications on if your employer pays for it, but the student athlete is receiving a benefit. So I'm actually having the tax lawyers at Pillsbury look into this and figure out what we think is the best process. In my non-tax lawyer view, I would say that, the taxable event would be the payment of the premium. And so let's say it's a $50,000 premium paid by the school. If the student athlete reports that on their tax return for the year they graduate from college, they should be taxed on the premium payment, which, considering they're not making any money during that final year, would probably be the only money they would report on their tax return. And so, that may or may not be taxable. And it's a consideration that athletes have to take into when they're deciding whether to have the school paid for the premium.
So
some schools, like UCLA, actually require the student athlete to take a loan out from a bank to pay the premium amount. And then if they stay out of trouble, they don't get arrested, they don't do anything out of the ordinary, then after they graduate, the school will pay off the loan, and that would be a taxable event. So it's sort of a fluid issue right now. Student athletes right now are not taxed on their scholarships, the amount for tuition, but room and board might be taxable. So the tax questions are actually kind of intricate and interesting at the same time. And I know those two words don't usually go together, tax law and interesting, but in this instance, it's probably true.
Well, in terms of interesting, let's talk about insurance law, which is your specialty. How have you seen that expand for college athletes over the years?
Well, a lot of college athletes and professional athletes purchase something called permanent total disability insurance. And about 6 or 7 years ago, there was an endorsement or rider created as an add-on to that, which was loss of value insurance, which in a very quick thumbnail sketch insures the difference between your anticipated first contract as a student athlete and what you actually sign as your first contract because you got injured during the policy period. So in your last season of collegiate athletics, if you suffered an injury and that injury caused you to drop in the draft, which caused you to earn less money than was anticipated, loss of value insurance is supposed to cover the delta. Professional athletes do the same. It's a different situation because they look for their free agency year, restricted or unrestricted, and they also look to buy the policy before their first salary arbitration year, for example, in Major League Baseball.
Now, is that for every sport in college?
It's the income-producing sports, so football, basketball, baseball, and hockey.
And so does that just cover the athlete on the field? Suppose that I'm an athlete who's going to an event where I'm getting paid by the sponsor, and I'm in a car accident along the way that ends my career. Does the loss of value insurance policy kick in then?
Should kick in. Most of these loss of value policies cover any kind of injury, whether it's sports related or otherwise.
And so how have you seen them increase in value and increase in premiums over the years?
So the premiums keep going up. Some things are happening right now, like it's very difficult to get loss of value coverage for baseball pitchers, and some of it depends on how old the pitcher is. Position players are a little easier to insure because there are not as many issues with shoulder and elbows.
Would anyone want to cover a pitcher with the Orioles?
Yeah, I'm not going to comment on that.
Well, you're a Dodger fan. You don't have to.
As a diehard Dodger fan, yeah. I just hope the Nationals aren't as good next year. So that's the key.
Well, so let me ask you another question regarding to insurance. Is it based, what if the NCAA were to say, we're going to start going with a captive insurance policy for this now and cover our own athletes? Would they be entering the lucrative market? Potentially.
I haven't really analyzed whether captive insurance would be a great idea for the NCAA or not. As it currently stands, the London market is the only market that really insures these types or issues these types of loss value riders on policies. A few years ago, you can insure about 60% of your anticipated first or next contract. Now it's coming down to closer to 50% because of the number of claims. In my experience, PTD, which is permanent total disability claims, tend to get paid more quickly and without much challenge. Loss of value claims almost universally get denied initially, and then if you hire the right lawyer, someone like me, the claims are ultimately paid after some battle with the insurance company. But it's an interesting little area of the law, and one that I think every student athlete should take advantage of if you're going to be a top draft pick in one of the major sports.
And what about those who choose to play abroad, say play basketball in a country like China? What are the insurance implications for that?
So the Chinese Basketball Association had recently announced that their athletes could purchase disability and loss of value insurance through a Chinese insurance company. So I think it's a similar type of situation, although I haven't seen one of those policies, haven't analyzed one of them, but you would assume it would be based on the London market model. And I think it applies once you become a professional in China.
So where do you see the insurance market moving for college and professional sports? Do you see more and more obtaining it, or do you see it becoming more and more of a benefit that more agents are savvier about?
I think it is becoming more and more prevalent. You mentioned Zion Williamson, so Duke bought the policy for him, as I understand it. It was not an inexpensive policy, but there was no payout on it because he was still drafted high enough that there was never a triggering event. And I would say, the vast majority of policies issued to professional and collegiate athletes like this never have a claim. So at a certain level, the insurance policies are critically important to ensure that if you can never play again, you get paid off. And one little known fact is, professional teams buy these policies as well. They don't buy the loss of value policy, but they do buy a disability policy, ensuring they're guaranteed contract players. So like Steph Curry will probably, his contract's guaranteed, or portions of his contract are guaranteed by the Warriors. And so the Warriors may have an insurance claim after a certain elimination period. That once that's triggered, the insurance company will pay the Warriors about 60% of the guaranteed contract amount that they're required to pay for Steph, depending on how long the injury lasts and how many games he misses.
Now, do these contracts with the insurance companies, do they also cover the sponsorship dollars? For example, LeBron James just signed $1 billion contract with Nike for lifetime sponsorship. Would an insurance policy cover that?
You could potentially cover that. Most of them don't. Most of them are based on what their anticipated professional compensation is. But there's an old adage, you can insure basically anything depending on how much you want to pay. So I think you could probably insure the endorsement value. There's a little known policy that sponsors can take out called death, dismemberment, and disgrace insurance. So if an athlete disgraces the brand, they may be able to have insurance to pay off the contract they signed with the athlete. So there's all sorts of little niches within the sports and entertainment insurance world that a lot of people don't know about and aren't very. It's not reported as often as you might think. It's funny because if you were to run a search for loss of value insurance and look at claim payment history, you will see articles saying that the claims are never paid, and that's just not true. Every claim I've been involved with has been paid. So it's just not reported, mostly because you've got HIPAA issues that come into play with athletes and what their injuries are or aren't, and you also have confidentiality issues because most of these cases settle, and the settlement agreements, of course, include a confidentiality provision. So if you hear people out there talking about what they settled for, what they didn't settle for, always surprises me because I've never seen a settlement agreement in any of these cases that didn't require confidentiality. And people shouldn't be out there talking about what's covered and what's not covered and what kind of injuries an athlete has or doesn't have, because you've got serious, HIPAA implications.
Are there any of the major cases that you've worked on and prevailed that you can tell us about?
Well, I represented Mitch Moreland, who first baseman for the Boston Red Sox when he was playing at the Texas Rangers. I can tell you about it because it's the only case I was involved with that actually had to go to litigation. The insurance company initially sued Mitch. He had a loss of value policy. He hurt his left ankle, missed 100 games one season, and was about to become salary arbitration eligible, or he was in the second year of salary arb. And he signed for significantly less because he was 100 games behind his classmates, people with similar amount of MLB experience. And so I had to sue the insurance company, which was a London insurance company, but not Lloyd's. And I ended up having to sue his wholesale broker, who had made some significant misrepresentations on his application or made misrepresentations to the insurance company. It's all laid out in a complaint I filed in the in California Central District Court.
Now, your world is highly specialized and highly technical. How do you approach a player to buy this? I mean, do you go through his coach? Do you go through his agent if he was just drafted? I mean, how do you do the responsible thing and make sure they're covered?
Well, I've always been a big proponent of having people involved at the procurement process, having a lawyer with significant experience in this space, which there aren't very many, sort of figure out what the proper wording is when the policy is purchased. Unfortunately, that almost never happens, and the claims arise afterwards, and then you have to deal with the policy language that you have in place. One suggestion I've made before is having colleges and universities, the sports information departments and the athletic departments, have somebody review the policies rather than just...
Does that take place? Do they review the policies?
Well, it's an interesting question because, the athletic departments, if the school's going to be paying the premiums, they should have some responsibility to tell the kid about it and the student athlete what the options are and who's offering what. Some schools work with a specific exclusive insurance broker, which in my opinion isn't always the best thing because it kind of limits the market, and you also are sort of vouching for that broker's reliability and expertise. And there's an interesting...
To be savvy enough to know what's going on in a loss of value insurance policy.
Well, and once the NCAA announced that student assistance fund money could be used to buy these policies, and the schools were going to buy them, you got some charlatans that sort of came out of the woodwork and started, trying to get some of the premium dollars and commissions off those premium dollars, and they weren't really who they should be, and didn't have the background or the expertise to be in this space. There's a case right now in Arkansas. It involves a Arkansas running back named Raleigh Williams, who as a freshman broke his neck, came back from the injury, and as a sophomore led the SEC in rushing. So at the end of his sophomore year, they started thinking he was going to be a top NFL draft pick, first, second, third round maybe. So the school said, hey, we'll buy you a loss of value policy. He came back for his junior year, was excited about it, and in spring practice and spring training, he got tackled and broke two other vertebrae in his neck. And when he was in the hospital, the wholesale broker called the dad and said, hey guys, or actually it was the retail broker in that instance, I hope he's okay, but just on the insurance front, nothing to worry about because everything's covered. And then 2 days later, the wholesale broker, Raleigh decided to retire from football because his doctors told him that, if you got another hit, you could be paralyzed and be a quadriplegic for the rest of your life. So he retired from football, announced the retirement, and 2 days later, the wholesale broker issued an endorsement on the policy excluding any damages from neurocognitive injuries or spinal cord injuries. So then the Lloyds denied the claim, and we're off and running on $1 million lawsuit. I'm not involved in that case, but I've been following it closely because it's one of those instances where somebody messed up. The school supposedly didn't pay the premium on time. Nobody followed through on when the premium payment was going to be made. The retail and wholesale broker made some questionable decisions, and issuing an endorsement after the policy had already incepted is outrageous to me. But so you have some interesting players in that space where schools and universities should really have a good vetting process and try and figure out who the best people are to use. Brokers with integrity and character, and maybe run a search to see if any of these brokers have been sued before for fraud or negligence or insurance coverage issues involving denied claims.
I used to work in the world of reinsurance, and I can tell you right now I've never seen a bigger group of sharks swimming around in my life. But let me ask you a question. There was a recent major Midwestern university. They had a huge claim against them. They had no idea if their insurance company covered it. They said, well, we hope so. Turns out it didn't, and the state had to float a $500 million bond issue to cover their settlement for the case. Would it be in the best interest of universities and colleges to hire someone like you to go over their insurance position to make sure they don't have any unfortunate surprises like that?
Well, that's a great question. Insurance touches on everything, so higher education institutions need somebody to actually review their policies. They need somebody to fight for coverages, and helping them understand all of the insurance issues outside of the student-athlete context is important. Like you said, you don't want to be in a situation where you didn't buy the right coverage or enough coverage.
All right, Mr. Giller, again, thank you for your time, sir. It's been great interviewing you again. This is Jonathan Yates with HBCU Game Day Network. Thank you very much for joining us.
Thanks again, Jonathan.